Start. The suit was filed by the plaintiffs respondents for recovery of possession and arrears of rent against the defendant appellant here in staff para. The appellant was a tenant of the respondent's staff. The property in question is a residential house staff. The trial court, the first appellate court and the high court have concurrently concluded that the plaintiff is entitled to get possession of the suit property and arrears of rent staff. Thus, the suit was decreed against the tenant by such concurring judgments staff. Thereafter, an execution petition was filed in 2006 for executing the decree staff para. The only question raised by the learned advocate for the appellant in this appeal is that the execution petition filed in the year 2006 is barred by limitation in as much as the same was not filed within 12 years from the date of the judgment of the trial court, that is, dated 14/8/1981 staff para. In sum and substance, the case of the appellant is that the execution petition ought to have been filed within 12 years from the date of the judgment of the trial court without waiting for the decision of the first appellate court or the second appellate court staff. He has also submitted that there is no interim order granted by the first appellate court and the second appellate court staff. There was no hurdle for the respondents to file the execution petition within the prescribed period of limitation after the judgment of the trial court staff. It is submitted by the decree holder that the decree of the trial court and the first appellate court have merged in the decree of the high court passed in second appeal staff. It is further submitted that the order of stay was operating in favor of the judgment debtor during the pendency of the appeals and hence the judgment debtor continued in possession staff para. It is not in dispute that the execution petition has been filed within time from the date of the judgment of the High Court staff. The High Court dismissed the second appeal on 30/12/2003 staff. The execution petition was filed in July, 2006 staff. Thus, undisputedly, the execution petition was within the period of limitation from the date of the judgment of the High Court staff para. The aforementioned question raised by the learned advocate for the appellant is no more res integra, inasmuch as the very question is decided by a 3-judge bench of this court, in the case of Chandi Prasad versus Jagdish Prasad, under bracket 2004 8 SCC 724:2004 under bracket 4 AWC 3208 under bracket SC, wherein it was observed that in terms of Article 136, Limitation Act, 1963, a decree can be executed when it becomes enforceable staff. A decree is defined in section 2 under bracket 2, CPC, 1908 to mean the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit and may be either preliminary or final staff. A decree within the meaning of section 2 under bracket 2 of the CPC would be enforceable irrespective of whether it is passed by the trial court, the first appellate court or the second appellate court staff. When an appeal is prescribed under a statute and the appellate forum is invoked and entertained for all intents and purpose, the suit continues staff. When a higher forum entertains an appeal and passes an order on merit, the doctrine of merger would apply staff.